Okay. Good morning, everybody. I am Dr. Sangeeta Maitra, welcoming you all to today's webinar. The topic of today's webinar is Contempt of Court versus Freedom of Speech, a constitutional dialogue. Now, to begin with, I'll give you a very brief idea as to what is contempt of court and what is my notion of this entire debate before I go ahead to the panelists and introduce them to you. Now, contempt of court has been in discussion in recent times, and that is our reason for selecting this topic for today's webinar. A very important, a very pertinent topic, I must say. And to begin with, contempt of court has not been defined anywhere in the Constitution or any other legislation clearly as to what is the meaning of contempt of court. Now, it simply means when we are disrespectful or we are disobedient towards the court of law, which means that we willfully fail to obey the court or court order or disrespect the legal authorities. Then the judge has the right to impose sanctions, which could be in the way of fines, or it could be in the way of imprisonment if a person is found to be guilty of contempt of court. Now, coming to the Constitution, there are three main articles which primarily deal with contempt of court. They are Article 129, Article 142, Clause 2, and Article 215. Here, Article 129, it grants Supreme Court the power to punish for contempt of itself. Article 142, Clause 2, it enables the Supreme Court to investigate and punish any person for its contempt. And Article 215 grants every High Court the power to punish contempt for itself. So these are the three main articles which deal with contempt of court under the Constitution of India. But unfortunately, as I've said, none of them define or tell us exactly what does contempt of court mean. Now, contempt of court has been defined in an act called the Contempt of Courts Act 1971, where it has been described broadly to be of two kinds, civil contempt and criminal contempt. Our panelists will go into the details and discuss all that. My notion, the two main issues relating to contempt of court, in my opinion, are Article 19(1)(a) of the Constitution gives the right to freedom of speech and expression to all citizens, while contempt provisions curb people's freedom to speak against the court's functioning. So this is in fact restricting the freedom of speech and expression which has been given under Article 19(1)(a). If you're not able to criticize the court's functioning, then your freedom is curbed. And on the other hand, the law is very subjective. The law, then another issue which I have found with this contempt law is that the law is very subjective, which might be used by the judiciary arbitrarily to suppress their criticism by the public. So these are the 2 points which have come into my mind relating to contempt law, which is existing at the moment, and specifically the Contempt of Courts Act 1971. Now here I would like to quote Justice Krishna here, as he said that the law of contempt has a vague and wandering jurisdiction with uncertain boundaries. Such a law, regardless of public good, may unwittingly trample upon civil liberties. Now further, the assumption that respect for judiciary can be won by shielding judges from criticism misjudges public opinion. Surely an enforced silence in the name of preserving the dignity of the judiciary would cause resentment, would cause suspicion and contempt more than it would enhance respect. In my opinion, the purpose of contempt power should not be to uphold the majesty and dignity of the court, but only to enable it to function. In a democracy, people should have the right to criticize the judges. With this brief introduction to the subject, I welcome you all to today's webinar on Free Speech versus Contempt of Court, a constitutional dialogue. We have amongst us in our panel, Mr. Sanjiv Sen, who is an eminent legal personality and senior advocate, Supreme Court of India. We have amongst us Mr. Sudhanshu Ranjan, who is a renowned author and a veteran journalist. He has been associated with Doordarshan for more than 30 years. We have Mr. Dr. Lokendra Malik, who is an advocate with the Supreme Court of India and also an author. We have Professor Dr. Y.P. Singh, who is the Registrar of MNLU Odisha and an author. And we have Mr. Chirag Balyan, who is an assistant professor, Maharashtra National Law University, Mumbai. And the concluding remarks shall be made by Mr. Sajid Sheikh, who is also an assistant professor in Maharashtra National Law University, Mumbai. So now I request Mr. Sanjiv Sen to set the dialogue in motion. Mr. Sanjiv Sen.
Well, thank you very much, and good morning to everybody. The subject that has been chosen today is a very, very important one, and a very pertinent and a very relevant and a very topical one, I would say. And a lot of debate is going on at the moment regarding the one side of freedom of speech and the other side of contempt. Now, freedom of speech is an easier concept to understand, but as Dr. Sangeeta correctly pointed out, contempt is a concept which is not very clear to everybody. Therefore, I think let us go into the concept of what is contempt before we go into the discussion of contempt versus freedom of speech. Now, the background of the jurisprudence of contempt arose in the 18th century in common law. It is basically of the idea that the king can do no wrong, and if you criticize the king, you should be in jail. Therefore, in theocratic societies, even today, where the source of authority is the ruler of the judge, is divine, the blasphemy laws are very important. In those societies where the king is the source of authorities, there are many societies, many countries today that are ruled by a king and by a kingdom still. And their sedition laws take a lot of importance. And in countries like ours, which are governed by a constitution, which is the authority where freedom of speech is guaranteed and personal liberties become very important. And therefore, in countries like ours, it is necessary to strike a balance between contempt and freedom of speech. Now, the rule of law is a fundamental feature of our constitution, and the right to obtain judicial redress is a feature of our basic structure. This is very important to note. So therefore, protection of the administration of justice is very, very imperative for the existence of a civilized functioning of any free and egalitarian social order. The law of contempt secures, therefore, public respect and confidence in the judicial process, and provides a sanction for any act or conduct which is likely to destroy or impair such respect or confidence. In this respect, I would like to quote Justice Sawant of our Supreme Court in an old judgment, where he brought down this concept of contempt very, very clearly, why it is so important. It is very, very important for contempt to be there, and why it is so important. The rule of law, Justice Sawant says, is the foundation of a democratic society. The judiciary is the guardian of the rule of the law. Hence, judiciary is not only the third pillar, but the central pillar in the democratic state. In a democracy like ours, where there is a written constitution which is above all individuals and institutions, and where the power of judicial review is vested in superior courts, the judiciary has a special and additional duty to perform. That is, to oversee that all individuals or institutions, including the executive and the legislature, act within the framework of not only the law, but also the fundamental law of the land. Therefore, disobedience of the court's order strikes at the very root of the rule of law, and on which the system of the Indian governance is based. So there is no underlying, the importance of contempt. The concept of contempt is very, very important. Now, as I said in the beginning, you see, the more advanced the society is, the more democratic the society is. A study of the rule of contempt in various countries seem to suggest that criticism and freedom of speech have a higher role. And the more backward a society is, and more stronger the government is, the more restricted the freedom of speech is. Now, let us quickly, today the time is short, so let us quickly understand what the global scenario is. In European democracies such as Germany, France, Belgium, Austria, Italy, there is no power of contempt to commit contempt for scandalizing the court. Therefore, the criminal contempt part, as Dr. Sangeeta said, is practically non-existent. The judge has to file a criminal complaint or institute an action for libel. Summary sanctions can be imposed only for misbehavior during court proceedings. In Belgium, the media has been very critical of the functioning of the administration of justice and have strongly criticized individual judges. In UK, the offense of scandalizing the court has become obsolete. The last successful prosecution of the offense was back in 1931. In 2012, the Law Commission published a paper on contempt power, which is expressly recommended abolishing the offense of scandalizing the court. And the recommendations were accepted, and the offense was abolished in 2013. In the United States, contempt power is used against the press and publication only if there is a clear and imminent present danger to the disposal of a pending case. Criticism, however virulent or scandalous, after final disposal of the proceedings will not be considered as contempt. So this is very interesting as how the global scenario, how other countries perceive contempt. And I only talked of democratic countries. As I said, theocratic countries or countries, run by kingdoms like Saudi Arabia. I mean, there will be a very stronger contempt law, sedition, blasphemy, etc. In communist countries, the law of sedition and blasphemy, sedition rather, will be much stronger. Now, no discussion on contempt can be complete without the words of Lord Denning, which I repeatedly refer to, in any discussion on contempt, and I cannot but resist in reading this out as well. Lord Denning says, let me say at once, and I quote, let me say at once that we will never use this jurisdiction to uphold our own dignity. That must surely rest on surer foundations. Nor will we use it to suppress those who speak against us. We do not fear criticism, nor do we resent it. For there is something far more important at stake. It is no less than freedom of speech itself. All that we ask is that those who criticize us should remember that from the nature of our duties, we cannot reply to their criticism. We cannot enter into public controversy. We must rely on our conduct itself to be its own vindication. Sometimes an upright judge is unjustifiably criticized. The best course of action for such a judge is to ignore baseless criticism, but pay heed to honest and correct criticism. He should have broad enough shoulders to shrug off baseless comments without getting perturbed or influenced. According to me, these words of Lord Denning is no more pertinent than it is today in India, where a correct balance must be struck between the law of contempt and the right of freedom of speech, which is guaranteed to every citizen of India under Article 19(1)(a) of the Constitution. I will not go too much into the provisions of the Constitution, as Dr. Sangeeta has already introduced them. The source of the contempt power, as she correctly says, is Article 129 to 15 and 142 to both the Supreme Court and the High Court. And these courts derive this power of contempt being courts of record. Now, what is court of record is for another day, another discussion. But to put it very simply, our courts of record preserves our judgments for eternity and perpetuity, and for, subsequent courts, subsequent judges who sit are supposed to follow the precedents. We are a precedent-driven society, and therefore we are duty-bound. The citizens are duty-bound to follow the judgments that have been passed, and otherwise the dignity of the court erodes, and there'll be a totally lawless society. And Contempt of Courts Act basically divides the contempt action into a civil contempt and a criminal contempt. Civil contempt basically is that every judgment, to put it very simply for our viewers, is that every judgment ought to be followed, and a disobedience of any judgment calls for contempt action. A criminal action criminal contempt under the Contempt of Courts Act has a very wide connotation, and that is where the problem arises. Criminal contempt is as defined as by the Contempt of Courts Act, is an act which scandalizes or tends to scandalize or lowers or tends to lower the authority of any court, prejudices or interferes or tends to interfere with the due course of any judicial proceedings, or interferes or tends to interfere or obstruct with or tends to obstruct the administration of justice in any manner. Now, these words are so vague and so wide that different judges have interpreted these in different ways. The civil contempt, I don't think anybody can have any issue with in a civilized society. As I read out the words of Justice Sawant particularly, we are governed by the rule of law. Judgments must be followed. If the judgments are not followed, the authority of the courts go. If the authorities of the courts go, if the authority of the judiciary goes, we will turn into a lawless society, which is against the fundamental principle of rule of law, which is against our constitution. Now, the constitution guarantees the right to free speech and
If you
expression.
could kindly wind up, your
Yes,
allotted 10 minutes is over, sir. I'm
yes,
sorry to interrupt you, but if you could
yes.
kindly.
Just 2-3 minutes. So therefore, whether it is press trial, whether it is freedom of speech, uh, the balance it sheds a very thin line. And in fact, in the coming week, two very important cases are coming up in the Honorable Supreme Court, where our colleague Mr. Prashant Bhushan has in fact criticized the judges personally, past judges as well as present judges. Those two matters are coming up. And in fact, he has also challenged the entire provisions of the criminal contempt provisions of the Contempt of Court Act, and has said and claimed that it is unconstitutional. So it will be very interesting to find out as to what the outcome of the cases is. So basically, there are two different aspects. One is criticizing the judgment, one is criticizing the judge. Criticizing the judgment, a fair criticism is permissible, a fair criticism is justifiable, but following of the judgment is imperative. Otherwise, it leads to civil contempt. But as I said, criminal contempt is a much wider and a vaguer connotation. And I'll end by saying that in a democracy, of course, the purpose of contempt power can be only to enable the court to function, or should be ideally. In other words, the people should be free and have the right to criticize judges and judgments, but they should not go to the extent of making the functioning of the judiciary impossible or extremely difficult. With those words, I end my address, and thank you very much.
Thank you very much, Mr. Sen. It was very enlightening. You spoke from the concept to the present situation, very enlightening. Now I would request Mr. Sudhanshu Ranjan, eminent journalist and renowned author, to speak on the issue. Mr. Sudhanshu Ranjan.
Thank you, Sangeeta, and all the co-panelists, Mr. Sanjiv, Singh, Dr. Lokendra, Malik, Sanjiv, Balyan, Sajid, Sheikh. I think I'm not missing any name. So after this erudite lecture of Mr. Sanjiv Sen was given a panoramic view and a global scenario of the contempt provision in the entire world, in European countries and other countries. He has given a fairly, I think, very exhaustive information. What does it mean and how different countries are following this law. So I don't have to elucidate or elaborate on it much. Two basic things which you have already clarified, that there are civil contempt cases and criminal contempt cases. So provision of civil and criminal, nobody can dispute that there is a need to have civil contempt, because not a single judgment could be implemented if there is not this provision of civil contempt. Unfortunately, I would like to say that the courts are very lenient in matters of civil contempt. I have personally seen in clear-cut cases of contempt by the government, the judiciary does not take action. And one of the major reasons behind this huge number of litigation is that the contemners are not punished. When the government of India does not comply, I'm very sorry to say, when there is an adverse judgment, most of the senior bureaucrats supported with eminent legal counsel and even retired judges will sit with magnifying glasses poring over where is the lacuna and how to circumvent the judgment. For months together and years together, it will not be implemented. If it is a case of government employee who is so scared of filing a contempt against the secretary because the contempt is filed by name, he will be harassed so much that he will be forced to quit, he will be suspended on some other grounds, and the court does not come to the rescue of the victim. That's the most unfortunate part of this contempt provision, that you say that civil contempt power is needed for the compliance of the order, for the rule of law, but it is the court which says that there is clear-cut violation, clear-cut circumvention. The authorities have refused to comply, and still they refuse to take any action. I can tell you with all the emphasis at my command that if 5 senior officials of the government of India are sent to jail, there will not be a single case of contempt so far as government is concerned. The judgment will be implemented. Unfortunately, the courts turned a Nelson eye. They don't want to punish. I don't know what is the problem, why judges are not so bold enough to send them to jail. First thing. Second, criminal contempt. Obviously, in a democracy, in a free society, there cannot be any place for criminal contempt. When you refuse to take action against obstreperous government officials, I don't know why should you punish genuine criticism. Criticizing judgment, okay, fine, that is one thing, and for I don't think people are punished. And to be fair to judiciary, not many people have been punished for the contempt of court in criminal contempt. But since the typical sword is hanging, not many people are courageous enough to criticize the judge or to criticize the judgment. Maybe there was a time when it was thought that the king can do no wrong, and the law of contempt goes back not only in the 18th century. The most famous case in 1631 in Britain, the Court of Assize, when a person litigant threw brickbat at the judge and he was immediately sentenced and executed then and there. That was in 1631, and now the same country has abolished this contempt provision. There are so many, how Raleigh was executed. There are so many cases, I don't have to go into those details. And how in 1765, it was Justice John Yeardley Wilmot, who in fact defined what is contempt. And the very genesis of this contempt law lies in judgment which was never pronounced, because it was found that the writ was wrongly titled. It was R versus Allman, and wrongly it was titled R versus Wilkes. Allman was a bookseller and was published something against Justice Lord Mansfield, and so there was a case against him. But when the warrant was issued, it was found that the person named is wrongly named there. So there was a move to amend the petition. But the sergeant said that, no, it is against my honor, I cannot do this. And ultimately, judgment could not be pronounced. After some years, it was the son of Justice Wilmot who published the whole paper, and this whole concept of the criminal contempt came into existence. So that is history. But now most of the countries are not following it. Even India, not many people have been punished, but the threat is there. I personally feel that it goes against the principle of natural justice. Nobody can be a judge in his own cause. Sometimes the same judge decides, and even if the other judge decides, the sense of fraternity is there that, okay, if I don't protect my brother colleague, then I will not be protected tomorrow by the same person. So I think it goes against the principle of natural justice. You have plenty of laws to defend yourself under slander and defamation. So many things are there. Even defamation is a criminal offense, and there is a demand to abolish that provision of the IPC that has not been done. So you can take recourse to those laws, you can be protected. I don't know why truth is not a defense. Even after the amendment in the Contempt of Courts Act, which said that truth will be a defense, the Supreme Court and higher courts, high courts are reluctant to. And that happened in the midday case, because they say that we don't derive our power from the Contempt of Courts Act because we are courts of record. Under Article 129, we have inherent power to punish for contempt, so we don't have to depend on the Contempt of Courts Act. This is very unfortunate, because Parliament also represents the will of the people. And if there is a demand that truth should be made a defense, why should it not be a defense? Because if you commit something wrong, the Supreme Court has said in so many judgments about the Allahabad High Court, once it said that there is something rotten in the country of Netherlands, something like that. So we found that Justice S.N. Shukla retired without facing any punishment. So the Supreme Court's own committee found that he was guilty. Do you think that not a single judge has taken bribe? but not a single judge has gone to jail. So many bureaucrats, so many ministers have gone to jail. So is it the holy cow that every judge is rectitude and integrity personified? That is, the corruption is confined only to executive and only to legislature and judiciary, free, totally free from the taint of corruption? Absolutely wrong. But you are using that power, and so many judges, you have quoted Justice Daining. He has himself said in his memoir that once a lady counsel was arguing and she threw the paperweight towards me. It passed by, and again she threw the Butterworth's book. Again she passed by, and I kept cool. And then she said, "Okay, my lord, I wonder at your coolness and getting exhausted of my ammunition." She was not punished. So many things happen in different countries, they are not punished. So why to have this law? But since the time is limited and the remit is very short, you are talking about the freedom of speech and contempt law. But I would like to talk about some other things also, how the freedom of speech under threat from other things, not only from the contempt of court law, not only from this contempt provision. There are so many things which threaten freedom of speech, and in democracy it is unacceptable. On so many grounds, my feelings are hurt. A case will be filed. I will give an example, and I think Dr. Lokendra Malik would not mind, so I will not take the name of the professor. Last year, my book, Justice versus Judiciary, was published by Oxford. He also recommended the name of an eminent professor. I will not take the name. It was sent to him for writing the foreword, but that eminent professor who has successfully created an image that he is a great scholar, I don't know whether he's a great scholar or not, he sent threatening mails to Oxford that if you publish the book, you will be punished for contempt, you will be punished for defamation. But since they still went ahead, he sent another mail that lawyers will come and they will attack your office. Still, if you go ahead, then you may have to pulp all the copies. So he made the most mischievous use of the threat of contempt just to sabotage the publication of my book. He's a great scholar, and Justice Lokendra Malik has published a book from Cambridge in his honor. So I will not take the name. I will not misuse this platform by taking the name. But this is how a so-called eminent professor tries to stifle the freedom of expression. Second thing, so many, because time is very limited. For everything you say, my feelings are hurt. I would just like to give a brief background of this section 295A of the IPC. In the decade of 1910 and 20s, the communal atmosphere was completely vitiated. So there was an attempt by the leaders of different communities to have amity. So it so happened that Swami Shraddhanand, who was in Hardwar, some Muslim leaders went there and they said that, can we have a place for offering namaz? And Shraddhanand said, yes, this is what you can offer namaz. They were quite impressed that if this kind of amity, this kind of communal harmony is there, then the country would grow. So Swami Shraddhanand was invited by Jama Masjid to deliver a speech, and he spoke from the pulpit of Jama Masjid on communal amity, and he started his speech with the hymns of Rig Ved, Ved ki richa ke saath shuru hua. That was on 4th April 1919. Still the atmosphere was so vitiated that Mahatma Gandhi had to go on a 21-day fast from 24th September to 8th October. I don't remember the exact date, for this communal harmony. But still there was not so much improvement, and Swami Shraddhanand, who spoke from the pulpit of Jama Masjid, was shot dead by one Muslim. His name was Abdul Rashid on 23 December 1926. And Muhammad Ali, who had been the Congress president, he came forward to support Abdul Rashid, and 2 days later, Mahatma Gandhi said that we forgive Abdul Rashid. So it went on busy, but became very poisonous. There was one book published against Sita, Mother Sita. Sita was painted in a very derogatory words and painted like what I should not even tell these things, like a prostitute. So to counter that book, another book, Rangila Rasool, was published, which described the marriages and sex life of Prophet Muhammad. So a case was filed against the publisher because the author's name was not given. He was Chamupati, he was our Samaji leader, but his name was not given. In the court, the judge said that which law has been violated. He wanted to know which law has been violated. You say that our feelings have been hurt, but under Article 153, there should be some violence, there should be some clash, some communal right. No such thing has happened. So under which law do we want the publisher to be punished? So they had no answer, and the publisher Rajpal Mahashay was acquitted. But in the court, Rajpal Mahashay was murdered, and the murderer Ilmuddin was caught. He was tried and he was also hanged. So there was a demand that you should make a law that if something hurts someone's feeling, then he should be prosecuted, and 295A was added. Now the section is being abused like anything. There must be a right to offend, and you must defend the right to offend. If there is no right to offend, then I think there is
We are
no.
running short of time, sir. I'm
Pardon?
sorry to interrupt you. We are running short of time, sir.
I know. In 1 minute, I will just finish. If there is no right to offend, then you cannot have any freedom. If you just be goody to everyone, if I find that there is something wrong in Hinduism, if Sati Pratha is wrong, I should criticize Sati Pratha is wrong. If triple talaq is wrong, it is wrong. How do I hurt the sentiment of anyone? So freedom of expression is being stifled more by these things. Contempt of court is of course there, but not many people have been convicted. But these things and such professors, they are bigger threats to the freedom of expression. Thank you so much.
Thank you, Mr. Ranjan, for your bold speech. Thank you so much. I would request the speakers to please stick to the time limit of 10 minutes. Next, I would like to invite Dr. Lokendra Malik, Advocate, Supreme Court of India. Dr. Malik.
Thank you, Professor Sangeeta, and good morning to all my distinguished colleagues who are panelists for this discussion. Today's subject is very important. We have just heard a scholastic speech of Mr. Ranjan, and my senior colleague, Mr. Sanjiv has also covered many aspects of the law relating to contempt. I will not repeat whatever has already been said, as all of us know that the contempt power is a constitutional power of Supreme Court of India under Article 129 and the High Courts under Article 215. And a particular act, Contempt of Court Act 1971, is also there, under which the court can punish the contemners. Today, the biggest issue is the use of contempt power. All of us have fundamental rights, and I strongly believe that the courts should use contempt power rarely, and the court should respect the fundamental rights of the people, their freedom of speech and expression, and the courts should have patience and restraint while exercising this power. In case of Prashant Bhushan, we have noted that the Supreme Court has issued suo motu proceedings. I think this kind of proceedings should not be initiated so early against a person, against an activist who has contributed a lot for the promotion of rule of law, human rights, and personal liberties in the country. And Justice Krishna Iyer has said that the biggest defense or the biggest weapon in the hands of the courts against contemners is the best performance. The judiciary should focus on performance. All of us have seen what has happened during this COVID pandemic. Many migrant workers have lost their lives, and initially the Supreme Court had refused to intervene. I and my colleague Professor Yogesh Pratap Singh, we have authored a piece on this issue which was published in the Live Law. Again, we have noted the case of Justice Shukla. Two chief justices of our country made recommendation to the Prime Minister and the President to remove Justice Shukla. CBI had registered FIR against Justice Shukla, but no action was taken against him. And I'm surprised that he took salary without any judicial work for almost more than 2 years. No action. There is no provision of suspension of Supreme Court and High Court judges. and it is very difficult to impeach them. So I think the judges should be ready to face criticism. We are governed by rule of law. We are governed by a democratic society, and judges are holding constitutional office. So they should not be so much touchy that if someone publishes something, then immediately there is a so moto proceeding. There are many issues relating to people where I think the court should show more promptness and judicial vigilance. We have seen the cases of Jammu and Kashmir is still lying in the Supreme Court of India. The constitutional validity of 370 abolition is not yet decided, and many other important issues are still pending. So lawyers, professors, media persons, they all, and not only these people, but even ordinary citizens have full right of making academic scrutiny of the judicial functions and their verdicts. Recently, I and Professor Yogesh Pratap Singh have also written a piece on Supreme Court judgments. Nowadays, it is very difficult to read Supreme Court judgments. We have seen the trend of judgments, 500 pages, 1000 pages, 1500 pages, 2000 pages. So are these judgments or theses or books? I think we had published a critical piece about Supreme Court judgments. My friend Professor Yogesh Singh gave it a title, Prolixity of Supreme Court Judgments. So I believe that this contempt power should be used with caution and only in rare circumstances, and its main use must be against those who willfully disobey the judicial orders. But so far as the criticism is concerned, I think Supreme Court judges should not be so much touchy, and they should give a response through more performance, their judgments, and protection of personal liberties of the people. During this pandemic crisis, we have hearings through this virtual system. This virtual system has become the part of our life, and this is also a fact that not only thousands of lawyers, but millions of lawyers are facing severe financial difficulties. But the court is not taking this matter seriously. Someone had filed a PIL and requested the Supreme Court that the lawyers should be allowed to take some other businesses, but they are not allowed, because there is no provision, there is no provision in the Advocates Act, and ultimately the government has to amend the Advocates Act. The Supreme Court can obviously recommend to the union government to amend the Advocates Act, and the Supreme Court can start the physical hearings, because this virtual system is not an option, is not an alternative of the physical hearings. So this is my view, that this contempt power should not be used as a tool to suppress free speech, and people should have full right of making academic scrutiny of judicial performance, judgments, and but I would also like to say that if someone willfully tarnishes the reputation or image or conduct of a judge without any justification, without any evidence, only in such rare cases this power needs to be exercised. Thank you very much.
Thank you, Dr. Malik. Thank you for your invaluable speech, and thank you for sticking to the time limit. Now I would request Professor Yogesh Pratap Singh, Registrar MNLU Odisha, to come and deliberate on the topic.
Thank you, Dr. Sangeeta. I am also thankful to all the panel members for their enlightening and passionate speeches and addresses on contempt of court and free speech. I thank organizers, especially Dr. Malik, for inviting me to speak on this very relevant and pertinent issue. Discussions are going on in the country on all these issues. I think Contempt of Court Act, all the three previous speakers, they have already emphasized. I will try not to repeat again, but I don't know whether it is possible or not. In 1950, we made a new beginning, but I say it's a paradoxical beginning. It was a beginning because we adopted a new constitution, which emphasized immensely on liberty, equality, and freedom of thought and expression. But unfortunately, we adopted all the legislations, all the laws which were prevalent and which were passed and which were drafted by the alien government, British, with a completely different motive and objective. We have a long list of legislations, whether it is Land Acquisition Act, Forest Act, Official Secrets Act, Indian Penal Code, Indian Police Act. We very often criticize and we wrote a joint piece recently on the conduct of the police. We frequently criticize that police is not performing well. Police is involved in various kinds of illegitimate and illegal activities in the form of custodial torture, illegal detention. This Indian Police Act was passed in 1861 after the mutiny of 1857. And the object was to give more powers to the police and police system so that such incident will not be repeated in future. But we adopted all those laws. Yes, Constitution, there was a provision in the form of Article 13, Clause 1, which says that all the pre-constitutional laws, existing laws, if they are found inconsistent, with the Constitution, especially with Part 3 of the Constitution, they will be void ab initio. They will be void to the extent of inconsistency. But this was not very simple, because there was no automatic process to filter all these laws which were passed by the British and which were not in consonance with the provisions of the Constitution. There was no automatic filtration method given by the Constitution. And what we have to do, we have to one by one, we have to challenge these laws in the High Court, in the Supreme Court, and then if High Court and Supreme Court will find it unconstitutional, they will declare. But this was also not very simple. It took 70 years, because the High Court, Supreme Court is also working with that mindset. So one, we adopted all the British laws, and then we also adopted that mindset, colonial mindset, which still I think we are not in position to leave it. It took 70 years to decrypt that Section 377 of the Indian Penal Code is unconstitutional. It is archaic. It is not in consonance with the provisions of the Constitution, equality and liberty and justice. It took 40 years, 45 years to decide to declare that Section 303 of the Indian Penal Code, which was made for the protection of the British jail officials, unconstitutional, because there is no relevance of Section 303. So it depends on the Supreme Court and High Court, which is still working with its colonial and feudal mindset. Just Mr. Sudhanshu Ranjan, in his very passionate address, he I think briefly referred how Supreme Court and High Court is functioning. The same mindset we can find out when we see when government decided in 1950s, when Constitution, because government has to implement so many principles given under directive principles of state policy, and the government decided that we'll give reservation and affirmative action for the weaker section of the society. And if you see the history, you will find how Supreme Court and High Court registered to this affirmative action policy by the government. I remember Champakam Dorai Rajan, and there are the case which led to Balaji versus State of Mysore, where first time Supreme Court said that 50% reservation we can give. If you see the background, there were many attempts made in the Karnataka. Earlier it was Mysore, and all the attempts were rejected by the High Court, Mysore High Court, declaring that this is unconstitutional, this is not permitted in the constitution, because we had all the judges coming from elite class. The same mindset is also reflected when we deal with the privileges aspect of various organs of the state, including the legislature and executive and judiciary. Constitution mentioned, for example, that legislative privilege, and it was clearly mentioned that subject to the provisions of this law, subject to the provisions of a law made by the parliament. And whenever we use this phrase in the constitution, it means a law is required to codify and to provide detailed law and framework for the protection of privileges and to define what is and what are the limitations. Till then, they can enjoy same privilege as the members of the House of Commons they were enjoying. Even after 70 years, no political party is willing to codify. No political party is even willing to start this process that we should codify the legislative privilege, because once it is codified, it will be limited, and they cannot take bribe for the voting, and they cannot take bribe for asking questions in the parliament. The same mindset applies to the Contempt of Court Act also, which is also given as a kind of privilege to the judges of the High Court and Supreme Court. And this also, its origin lies in England, where the king, who used to be considered as the incarnation of God, besides being the head of administrative and legislative function, and he used to function as a fountainhead of justice. But now we are living in a different age altogether. The adjudicatory function is now transferred from God and angels to normal, ordinary human beings who are trained in law. So this divine origin, in my opinion, and divine function concept does not fit in well with the idea of constitutional democracy. The Contempt of Court Act is also a British, if you see the history, initially it was passed in 1926, which was replaced by 1952 Act, and finally by 1971 Act, Contempt of Court Act 1971. And everybody will be surprised, I think you must be aware that even 1971 Act did not provide truth as a ground, as a defense in contempt of court. This was done in 2006 by amendment in Contempt of Court Act. We often rely on decisions of the US Supreme Court, decisions of the Supreme Court of England and earlier House of Lords, but we don't follow when it comes to accountability, when it comes to developing good convention, good practices, we do ignore them conveniently. In United Kingdom, United States, they have made substantial amendments. So they also had in past criminal contempts and civil contempts. Civil contempts, even I think they practice even today. But they have made substantial amendments to constrain the powers of the judges who might otherwise have acted to vindicate their authority and majesty. I was reading an article by Justice A.P. Shah, and it was mentioned, Mr. Sanjiv Sen also, that in UK, the Law Commission has already recommended, and this recommendation was made in 2012, and they recommended abolition of law of contempt altogether in England. So they are discussing the abolition of whatever they have still they are left residue of Contempt of Court Act. But our Law Commission, when matter was referred to Law Commission, and Law Commission was asked to give a report. The Law Commission said that because cases are rising on the contempt, and this rising number of cases justify that we should have, there is still relevance. I don't know what kind of logic it is. Rising cases justify the relevance of continuance of contempt, the Colonial Contempt of Court Act. And because Law Commission chairman is also a Supreme Court judge, retired Supreme Court judge, so they have to, most of the time they have to show the solidarity. Everybody, unless we have somebody like Justice A.P. Shah or Justice Krishna Iyer or Justice Gajendra Gadkar. But we are taking judges and encouraging judges to take suo motu cognizance. This is very, very surprising, I think. Suo motu cognizance. And suo motu cognizance they will take, and they will constitute a bench, because the Chief Justice of India is the master of roster. Again, a very controversial topic, controversial issue. And he will constitute a bench of his own brother judges. Now, we can't expect justice in this kind of scenario. When judges are working as a normal human being, but they want divine privilege and divine concept of justice delivery system. When it comes to accountability, they evade all kinds of, all attempts to evade all kinds of constitutional and legal accountability. Long we discussed whether judiciary is a state under Article 12 or not, whether judiciary should also be accountable for the violation of fundamental rights. This question was raised long back, but till now there is no authoritative answer from the Supreme Court. And they are trying to evade that judiciary should also be declared. In the United States, it has been done long back, so many years. So briefly, there are others. Right to Information Act. Supreme Court fought for many years that they should not be part of the Right to Information Act. Recently, I think two years back or 3 years back, the Supreme Court accepted that the Office of the Chief Justice of India is also subject to Right to Information Act. Otherwise, Supreme Court was fighting in the High Court, Delhi High Court, that we should not be declared public authority under Right to Information Act. Very surprising. Collegium, functioning of the collegium. So there is no accountability. They are not accountable to anybody. So they evade all kinds of accountability, and they want divine powers, divine privileges, and divine nature of the functioning of justice delivery system. So briefly, I would also say that Supreme Court is scandalizing itself by engaging in all these activities, and the law has already been challenged, but I have very less hope that it will be stuck down, or it will, scope of the criminal contempt at least will be restricted by the Supreme Court. With all this, I think I rest my address. Thank you very much.
Thank you, Professor Singh. Now I would like to invite Mr. Chirag Balyan, Assistant Professor, Maharashtra National Law University, Mumbai. Mr. Balyan.
A very good morning to all the co-panelists and the participants. First of all, thank you for joining us on a Sunday morning for this always relevant topic of contempt of court vis-a-vis freedom of speech and expression. As a last speaker, there are advantages as well as disadvantages. Advantage in the sense I had an opportunity and privilege to listen to the views of all the eminent experts in the field, and disadvantages, I have to make sure that it does not come at a cost of repetition. As the title itself suggests, free speech versus contempt of court, a constitutional dialogue. The title in itself pitch the idea of freedom of speech and contempt of court as opposite. But in my opinion, my reading of the Constitution suggests they are not opposite. And it is this point I am going to emphasize in next 10 minutes allocated to me. We have been talking a lot from the perspective of contempt. But let's first talk about Article 19 of the Indian Constitution, which gives us freedom of speech and expression. Now, it is a settled law of land that freedom of speech and expression is not absolute. There can be reasonable restrictions. Article 19(2), which provides contempt of court as one of the exceptions, is also there in the Constitution. It's not the part of the colonial continuity. It is our constitutional makers who incorporated both freedom of speech and expression under Article 19(1)(a) and contempt of court under Article 19(2). So any discourse on freedom of speech and expression and contempt of court in the present era has to be situated in the realm of the Constitution. Now, coming back to freedom of speech and expression, we are having this panel. Let me give a very simple example. Our moderator asked at least 2 to 3 panelists to stop at a point of time. Is it violation of freedom of speech and expression? They were speaking, they had a freedom. Right? That's one way of looking at freedom of speech and expression. I'm not getting into whether she's state or not, but the ultimate idea is that even in day-to-day discourses, in day-to-day communications, there has to be some limitations. Because if there are no limitations, then definitely your freedom is going to also hurt someone else's freedom. So if we don't ask one speaker to stop, if we don't put a restriction on the freedom of speech, the other speakers' freedom is going to be restricted. So always we talk in terms of balance. Always we talk in terms of how these different ideas the conflict between these two ideas can be balanced. Let's look at it from this perspective also. When we talk about freedom of speech and expression, all of us have already spoken of what we wanted to speak about Supreme Court, High Court, and we have made a lot of reservations how Supreme Court is working. Can we say we haven't exercised our freedom of speech and expression? In fact, according to me, Article 19(2), all the exceptions, does not limit freedom of speech and expression. The fact that we have already exercised our freedom of speech and expression, this can be a literal view, a strict view, it means the restriction comes at a later point of time. And now what we need to do is, if we want ourselves to be protected, we need something separate from Article 19(2), which is not there in the Constitution, which is the right not to be decriminalized. Do we have such right in the Constitution that a person should not be unnecessarily criminalized after making the speech? We don't have this provision, and the problem of criminalization is ever existing in the entire judicial system. So what exactly happens in a democratic, in a plural society like us? We have different interests, different communities. So our democracy is very, very vulnerable. And in a vulnerable democracy, how do we manage the conflicting interest is one of the core issues, which is not only just relevant today, is going to remain relevant till the democracy as a structure remains relevant. And these debates are always going to be relevant. How different interests can be balanced, and it was always also. So what we need to do in this particular setup, we need to have an informed society. We need to know how the dialogues, interactions, communication, conversations between us as a society happens. Now, as I see a lot of time what we do on the name of freedom of speech and expression, and as an academic, this is also my responsibility, because when I go to class, I have to tell my students that it's not just freedom of speech and expression, it's not just what you say, it's also the objectivity in your speech. It's also the intention which is behind your speech. A person in the guise of freedom of speech and expression cannot make very open or lame comments, cannot make unfounded comments. And what has happened because of social media, because of certain social media platforms like Facebook, LinkedIn, Twitter, etc., we just tend to make sweeping statement. Now, the intention behind that statement may be correct, but contempt law does not go into the intention. The contempt law just see whether your statement has affected the administration of justice, whether it has any repercussions on that. And if that is the case, nobody is going to seek an explanation. And therefore, if such kind of constructive criticisms are to be made, if academic criticisms are to be made, they should be well founded. And if they are not well founded and somebody misinterprets them and take it personally, then it should be that person's responsibility. So we need to be very, very conscious as a society. How do we conduct a discourse in our society? Second thing about contempt of court, my learned panelists have already spoken at least about 3 different facets of contempt of court. First way of contempt of court is when a person disobeys the order. When a person disobeys the order, there is no question of freedom of speech. Second is when the matter is sub judice. Say there are many contempt cases which are sub judice. Should we have this discussion at all? And if we are having this discussion, what should be the mode and manner of having that discussion? Because if we are having a discussion on the sub judice matter and that affects the administration of justice, that can also be called contempt of court. And for that very count, every day we have thousands of such media trials happening in our country. But judiciary really does not take cognizance of that. And it's also impractical for the judiciary. And third thing is what we are talking about today. The courts are scandalized. The public images of the court is lower down in the esteem of public. And now, the moment this idea comes that the public image of the court has been lowered down, we are assuming that there is some image of the court. If there is some image of the court, we have to ask ourselves this question. Who conferred or gave this image to the court? Has the court itself assumed this image? So that's the problematic part. First of all, when we talk about scandalization of the court. Second problematic part is, these are 2 distinct things. Scandalizing the courts, lowering the public images of the courts, the institutions, and for that matter, in that sense, it will apply to all the democratic institutions, be it Parliament, Supreme Court, Election Commission. And on the other hand, imputation which harms the judges. Now, imputation which harms the judges are to be divided into 2 parts because of the present system we have. Chief Justice, because Chief Justice of India is a Petra familias. He is the head of the institution, and therefore any imputation made to CJI in his capacity as a CJI is also an imputation against the institution. So I read a case some time back where one of the members of the bar made an imputation against the registry that the cases are not allotted properly and there is a lot of problems in the allocation of the case. And our Professor Yogesh Pratapji also highlighted about that point. Power of the Supreme Court, power of the Chief Justice as the master of the roster. Supreme Court took the cognizance of that complaint against the advocate and said, see, imputation against the registry is imputation against the Chief Justice of India, and that's why we hold you in contempt. That's the case which is of the Supreme Court. Is it fine? Is it just? Is it reasonable? It is for the individuals to decide. Next, we also have trends in our legal system, in our judicial discourse. We have many judgments wherein at least one judgment comes from Punjab and Haryana High Court and other come from Odisha High Court. Both comes from the era of 60s, where the High Courts held freedom of speech and expression is subordinate to contempt of court. And the reasonable restrictions, the element of reasonable restriction does not apply to contempt power. But that was later on rectified by the Supreme Court in one of the cases which involved the contempt case against the Chief Minister, because Chief Minister made an allegation that judiciary is only meant for the upper class. It is only meant for the rich, and judiciary is and courts are the instrument to suppress the poor. And that Chief Minister relied these observations on Marx and other communist philosophers. The court said that clearly this is a case of contempt. The court interpreted all the theories. It has been questioned by our eminent Professor Sathe whether it was fine for the court to get into those theories, but court interpreted those theories and court came to the conclusion those theory does not say anything about the judges. But is it just limits of on the freedom of speech and expression? Is it reasonable restriction on the freedom of speech and expression? We have to analyze ourselves. Our audience has to answer these questions. Then we have a case in the Supreme Court where Justice Hidayatullah confined the limits of contempt powers, and he said, except in the cases where the contempt is manifest, mischievous, or substantial. Manifest, mischievous, or substantial, we will not invoke criminal contempt powers. Now we have a parallel scenario in sedition, where in one of the constitutional bench judgments, the language of the article of the section 124 of the CPC, of the IPC was toned down. But we still know toning down of language didn't have any implication on how actual cases are being filed. So when that does not have an impact, whether this interpretation by Justice Hidayatullah that only in substantial cases, only in mischievous cases, contempt jurisdiction will be invoked, whether that will have an impact, the answer is questionable. So it is in all this spectrum we have to analyze. Another point which has been highlighted by two speakers at least today, when an imputation has been made against the judge, right? I have talked about CGI and how imputation against the CGI in his capacity as a CGI can amount to imputation against the institute. But what about other judges? Law of defamation is there. But clearly law of defamation is not applied by the judges, because we have to also think from the perspective of judge. Say, take a present, let me not give any contemporary illustration because matter is sub judice. Take an illustration that an imputation has been made against ex-judge. If an imputation has been made against ex-judge and ex-judge does not take any action, does not give any reaction, people will tend to believe that imputation may be true. So now it is a moral dilemma for that person to take an action. Now, should that person resort to defamation or should that person resort to contempt? That is very questionable. But I feel if a person is situated in that capacity, a person is tend to react. Now, should there be any kind of tolerance? There is a lot of debate about tolerance and intolerance, and we say that in terms of our parliamentary system that the things are not that tolerant, and especially against the present government, many imputations, but those are the elected government. There is an accountability, there is an institutional responsibility. Elections will happen after 5 years. But as far as judiciary is concerned, there is no question of accountability because they are not elected members. And if they are not elected members, how are we to ascertain the accountability? And Professor Yogesh has rightly pointed out how RTI thing evolved in our country, how Supreme Court itself registered, and later on they came up with a very good, excellent judgment. So when we say that there are a lot of problems in judiciary, but we also can't make a sweeping statement that everything is rotten. There are certain good things. There have been good judges. There are good judges who are delivering good judgments. But yes, there are few judges. So in that complete context, it is my opinion we have to look at the debate of free speech versus contempt of court. Thank you so much.
Thank you, Mr. Balyan. Thank you for your enlightening speech. You have covered a vast area. That is highly commendable. Now I request Mr. Sajid Sheikh to give the concluding remarks. Mr. Sajid Sheikh is an assistant professor of law in Maharashtra National Law University, Mumbai. Mr. Sheikh.
Very good afternoon to all the esteemed panelists and to the participants. Uh, though there was a restriction on the panelists not to repeat what already has been said, but here my duty and my obligation is to give a concluding remarks based on what our esteemed panelists have already said. So definitely that restriction won't apply to me, but I will try my level best to be as brief as possible. Also, I would like to thank all the participants for, attending today's webinar. Thank you to all the panelists for, expressing their opinion, expressing their, expertise on this very sensitive subject in a very lucid manner. Uh, Thank you to Dr. Sangeeta Roy, who explained to us about the various laws related to the contempt of the court and what are the issues which are hindering the freedom. Thank you to Mr. Sanjiv Sen, who started and, set the debate right by, saying that king can do no wrong to a constitutional, which was there earlier, but that is not applicable in the constitutional society we are living in today. And we definitely need to take clues from other good democratic countries and what they are doing there. And in the present day, he also highlighted there are certain cases which are there to be heard up in the coming days, which will help us to determine, what is the conclusion to this very debate of free speech and contempt. And thank you so much, Mr. Sudhanshu Ranjan, who is very, very opinionated and, speaks very fearlessly. And he said that leniency in the contempt by the government needs to be relooked, which already has been there. And truth should be used as a defense. And it is very questionable why truth is not used as a defense. And the freedom of expression should be strengthened and expressed without fear. Thank you so much, Mr. Ranjan. Thank you so much, Dr. Lokendra Malik, for bringing this very panel today together, on this very lively debate. And definitely you said that the use of contempt power by the court should be rare, and whenever used, it should be with restraint. And you reiterated what Justice Iyer said, that for judiciary, the best defense is good performance. And you also highlighted that academic scrutiny of judicial performance must be allowed. And definitely, I read your recent article on related to contempt. I must say that it is a very brave and a balanced piece of writing which you wrote there. And definitely criticism must be allowed, and only disobedience of orders should be considered as contempt, was said by you. Thank you so much, Dr. Yogesh Pratap sir, for saying that existing of old archaic laws threatens the democracy, and definitely legislative cleansing, it should become a norm, and same should be done with when dealing with the Contempt of Courts Act. Also, there should be more and more accountability in the judiciary. And the last remarks were of Mr. Chirag Balyan, and when he tried to bring this very narrative that the contempt laws and the freedom of speech, if looked at in a real sense, they are not antithesis to each other, they are not contrary to each other. And in this diverse society, in this vulnerable society and sensitive democracy, we have to really look at how this conflict between all these very interests should be balanced. And there, of course, should be a right not to be criminalized, because even in the academic sphere, in all the spheres, people are very, very, they're threatened, like they should not say anything which may appear to be a contempt, which may appear to be seditious or something like that. And criticism should always be founded, as he said, and that sweeping statements, it should be avoided. Lastly, I would just like to reiterate what Chief Justice Shri Gajendra Gatkar said in 1964 in a judgment. He said that we ought never to forget that the power to punish for contempt, large as it is, must always be exercised cautiously, wisely, and with circumspection. Frequent or indiscriminate use of this power in anger or irritation would not help to sustain the dignity or status of the court, but may sometimes affect it adversely. Wise judges never forget that the best way to sustain the dignity and status of their office is to deserve respect from the public at large by the quality of their judgments, the fearlessness, fairness, and objectivity of their approach, and by the restraint, dignity, and decorum which they observe in their judicial conduct. So lastly, there is a question for all of us to ponder upon, that is it the right time for the judges to avoid the shield of judicial office by invoking contempt for personal criticism received? This is a question. Nonetheless, we all citizens should take an oath to speak out in the cases whenever there is injustice, without any fear or without any favor. With this, I thank each of the panelists for their valuable time today, for their valuable expertise and opinion, which was very much needed at this very point of time. Thank you to so much to the moderator for doing a very, very difficult task of moderating, such esteemed panelists which were with us today. Thank you. There are hundreds of participants who have joined us on Zoom platform. There are hundreds who have joined us on YouTube platform. Thank you so much for being part of this debate today and attending this very, very lively discussion. Thank you so much. Thank you all. And only one thing, that we'll be sharing the feedback form with all the panelists. Now, please submit that very form before leaving. Thank you so much.
Thank you, Professor Sheikh. I would like to say a few words to all distinguished panelists, and a special thanks to all our participants. These are all webinar warriors during this Corona crisis. So I hope that the participants have found it very well discussion, and I'm personally deeply grateful to all of you. Thank you very much and have a nice day. Thank you.
Thank you very much.
Thank you, sir. Thank you, everyone.
Thank you, sir. Bye.
Thank you.
Bye.
Now the esteemed panelists, they can quit this very platform as they like. Thank you so much. We'll be live for a few more minutes while all the participants can fill up the feedback form.
And
We have shared the feedback form. You're requested to kindly fill it before leaving.